All right, Mr. Chair, you are now live.
Are we all good?
Yep, we're good, Chuck. All right, we're going to start the meeting.
Great.
Welcome everyone to the City of Annapolis Board of Appeals virtual meeting for October 6th, 2020. Council, I'm sure, have noticed that this is our traditional opening of the fall session on the first Tuesday of October. This meeting is being broadcast on the City of Annapolis YouTube channel. My name is Bob Gallagher and I chair the Board of Appeals. In accordance with the city policy during the pandemic emergency, the virtual meeting allows the public to observe the meeting through the video link. Public also has the opportunity to submit written testimony for this meeting through an online submittal process on the City of Annapolis website. Links to the YouTube channel and to the website may be found on the agenda, which is on the city's website on the Agenda Center. So we'll begin the meeting by asking our recorder, Tammy Hooks, to call the roll.
Mr. Gallagher,
Yes.
Mr. Zazali,
Here.
Dr. Chen,
Here.
Mr. Walsh,
Here.
Mr. Burnett,
Present.
Mr. Dews.
Present.
Wonderful. We've got a quorum. Before we get to the agenda itself, some notes for those watching on our virtual format. The people you see on the screen are members of the Board of Appeals and parties in the principal case on the agenda tonight, Appeal 2020-02. Also participating in the meeting are counsel to the Board of Appeals, Cheryl Woods, our recording secretary, Tammy Hooks, one or more city employees, Sally Nash in this case, and Julian Jack, who's running the technical side of things. Also participating, we have Joel Braithwaite, Assistant City Attorney and Counsel for the Department of Planning and Zoning. And we may have other city staff from time to time. We ask everyone but members of the board to mute themselves except when they are speaking. If you wish to speak during the meeting, raise your hand and unmute yourself and I'll call on you to speak. So I mentioned earlier, written public testimony is accepted through the online portal. Testimony submitted up until noon today has been forwarded to the board and will be made part of the record. This hearing will be continued to a date that we will announce later in the meeting. Let me get rid of that, sorry. Sorry about that. It'll be continued to a date we'll announce later in the meeting. Public testimony received until noon on the day of the resumed meeting will also become part of the record. Public testimony and other documents relating to the case are also available or will be available on the city's eTrackIt platform accessible from the city's website. We understand that website hasn't been working properly recently. We'll come back to that question later in the evening. So getting to the agenda, have the members of the board had a chance to review the agenda? Is there any suggestions, changes, comments?
Motion to approve agenda.
Great. All in favor?
Aye.
Thank you. Before we get to the appeal, we have first on the agenda the approval of an extension in special exception 2018-002. I've reviewed it and the draft of the decision extending the appeal, and it looked good to me. Have any members of the board have any suggestions or corrections on that? Okay, then we'll approve that. I'll stop by, Sally, and sign it at your convenience over on Gorman Street. So to the main event for the evening, we're coming back to the Appeal 2020-002 relating to the Certificate of Adequate Public Facilities issued by the Director of Planning Zoning relating to the lofts at Eastport Landing. In our last order in this case, we directed the applicants to take additional steps to comply with the requirement for mailed notice. That compliance with that requirement has been the subject of a renewed motion to dismiss by Mr. Hyatt on behalf of the applicants. But before we hear from Mr. Hyatt, I'd just like to ask Ms. Halleck to report on what applicants have done to comply with the mailed notice requirement.
If you want me to address the problems, but I will report back that pursuant to the board's decision and order in this case, where the appellants were to notify all tenants as well as the community association and members and the alderman, and that pursuant to the order, and reasonably notify based on ability to ascertain who the tenants were. And since then, we have submitted the notice as provided by the city and I've submitted an affidavit of notice to the city with regard to the notifications. So to summarize who they were sent to, there were 4 sections. The first is all of the tenants at the Watergate apartments sent to occupants. And I was able to obtain from the management that all of the addresses for all of the units, and all of those were sent. Secondly, there's a group of all of the tenants in the shopping center. Thirdly, it is the list of community associations within 200 feet, but out of an abundance of caution, I sent it to everybody on that list for Ward 8, maintained by the city, including the alderman. I do want to note that the alderman has had like 5 notices. He received it from the initial one. He received it in every single one of the notifications, the affidavit of notice. His name has been listed, or that alderman through the city has been listed. So those were sent. The last group is how to ascertain who the tenants are in the property owners within 200 feet. And through research and through my motion that response that I sent to the city, the way we did that is to send notices, and that's the recent notice, to the properties, occupant at the properties where any of the residents listed were not at the address of the property. So if the owners were listed at the property site, it would be assumed that they are the owners of the property as their residents and as their tax residents. However, so for example, if there was an owner that had a Washington, D.C. address, we sent it to that property, care of owner occupant. And so the notices were sent to all of those. And if you, in response to Mr. Hyatt's concern about the remaining 13 or 20 of updated, the most recent changes to that list. Now I represent that the list of 200 owners, property owners, the owners within 200 feet, it seemed like there were 200, but within 200 feet, that was provided by the city based on the tax code. And all of those were those had been sent through that. There were updates, like on any mailing. Sometimes the tax code is never going to be absolutely correct. So Mr. Hyatt noted there were approximately 20 changes. In cross-referencing that, 13 of those residents received, we mailed to owner occupants at the home. So there was only a remaining 7 that were not absolutely updated and did not receive if I say they did not, the property was sold and or the owner might have moved. So it's not perfect, but I will note in response to Mr. Hyatt's motion that the board did not the board was satisfied with the notices to the properties within 200 feet. I was in full compliance with the board's order that that the applicant were to notify the tenants. And that is what I did. That Mr. Hyatt only brings this up later. He could have brought that up at the prior hearing when the board implicitly found that the notifications were proper to the other owners. He waited to the last minute, to 2 days before, Friday before the hearing on Tuesday, and filed this motion complaining that the original list was not accurate. And at that, my response, I note that there was essentially a waiver here of that there is an objection to it's not perfect. Now, considering this, if 2 or 3 of the, it's always a moving target. If 2 or 3 of the owners move, how am I to know, and how is a party to know? And if a few of them are not notified, because that's not the tax identification, at some point the board has to use its judgment to say that it is satisfactory notification. So for several reasons, I've complied with the board's requirement. I've notified all the tenants. We've published it in the newspaper. I've provided the proof of publication that all requirements for notice on our part in accordance with the board's orders have been complied with. And Mr. Hyatt is bringing up a new and novel issue. The first is that the most few changes on that make it imperfect. And the second is that I think if he wants to address that the initial notice was for preliminary hearing.
Yeah, you'll get a chance to respond to him.
Yeah.
Okay. All right, so Mr. Hyatt's got a motion joined in by Mr. Braithwaite. Let's hear from Mr. Hyatt. And Mr. Hyatt, if you would, at some point, and what you had to tell us, please tell us exactly who should have gotten notice but didn't.
I'll do that. Thank you. As you have noted, I, on behalf of the applicant, am renewing the motion to dismiss this appeal 2020-002. 21.10.020 of the city code is burdensome. It's a lot of trouble. And Ms. Halleck has found out how difficult it is to provide the appropriate and proper notice required under the code. And she has failed to do it on 3 occasions. And on each and every occasion, she blames someone else.
Yeah, we know about the earlier occasions. Let's just focus on since the last hearing.
Okay, well, she believes I have sprung a matter on her at the last minute, but here's what happened and the timeliness of it. I think you need to be aware of this. On Ms. Halleck's affidavit, she stated as of the 17th of September, she sent out these notices. I didn't receive her affidavit until Friday afternoon, the 25th. So the following Monday was a holiday for me. After that, we reviewed what she sent, and we were surprised that there was no notice sent to property owners. So we looked at the list and we looked at the background, and we realized that she must have been under the assumption that the property owners received notice, those that are within 200 feet, back in August, and somehow that was okay. So at that time, we took a look at the list, and the list was antiquated. There was at least 14 or 15 people on that list that had transferred properties, and they did not own the properties anymore.
You were looking at Ms. Halleck's list or at the city's list?
I was looking at the affidavit, the list of property owners within 200 feet that was attached to Ms. Halleck's affidavit, which was the same list from August, and it was wrong. I didn't inspect it back in August. It's up to the appellant to provide notification under the city code. It's not up to us. It's not up to you. It's not up to anyone else.
Yeah.
And she received on September 10th a letter from Mr. Smith from the Department of Planning and Zoning with the form of the letter that was supposed to go to property owners within 200 feet and to tenants within 200 feet and to the various community associations. it's not right that she can do this and blame someone else and then just have a result of kicking the can down the road. You know, this appeal was filed in June of 2020. And, you know, the reality is the applicant is the one that's bearing the brunt and suffering, not the appellant. The appellant wins when this goes on month after month after month. And I can't think of any other tribunal that would put up with this. She's been given leniency. Prior to her, Mr. Rogers was given leniency. She can't seem to comply. And where she didn't comply, her affidavit's not correct. She did not give notice to all tenants within 200 feet. Very specifically, there's a Deals Produce, right, which is a business right in the parking lot. They didn't receive notice. It wasn't listed on her affidavit. There's a building across the street, 919 Bay Ridge, and there's multiple tenants in that building. They weren't listed. It's very tedious. It's very tiresome. It's burdensome. As I said before, we do it all the time. I have a paralegal in my office. When we file these cases, we spend hours and hours and hours, and we do it, and we try to do it right. This appellant, or these appellants, have not done it right. They have not. They could have given notice. They could have gone to the SDAT website. They could have obtained a list, a snapshot in time of all the property owners, and send occupant to each one of those addresses, as well as a letter, the form letter to the owner. You know, you pick and choose, and you make mistakes, and you rely upon others, and then you ask for forgiveness. This has happened too many times. I think it's an abuse of discretion if this board doesn't dismiss this case.
So you mentioned the produce stand and tenants is at 919 Bay Ridge?
Yep, 919. On my motion, there are exhibits, and we've outlined, or we've spelled out, we've color coded who didn't get notices, and it's not an insubstantial amount of individuals that did not get notice.
Well, I understand Ms. Halleck to say it's down to 7. Is that correct?
Well, I don't know if I don't believe that's right. I think there's 14 people that didn't get notice as property owners. There may have been some notice to occupant, but there's at least 14 property owners that did not get notice. So this is not a properly noticed hearing for sure, when we know that. And so you have that, and then we have tenants that I just told you that did not get notice either. And it's not right. It's just not right, because we can't have a hearing that's not properly noticed. And when you have the burden on the appellant and they don't bother to do it, then what am I supposed to do about it? Come up with a novel argument? It's ridiculous.
So I recall in your papers, and I think you mentioned today, you took a look at the SDAT database.
Correct.
Is there some reason that Ms. Halleck should have known that database is more reliable than the list provided by the city or from the tax rolls?
I don't know who gave her the list. The list from the tax rolls. I don't know where you come up with that. I think a practitioner has to read the code and determine how to react to it and how to comply.
But the code doesn't. Does the code say anything about the SDAT?
It does not.
Okay.
The city provided that list, Mr. Gallagher.
I don't
Chair.
think so. I don't think the city provided that list.
All right. Well, we're going to hear now from Mr. Braithwaite, and maybe he can address that.
The reason the city joins the applicant's motion, it's because, as now have been conceded, at least 7 people by appellant's count did not receive notice. And the first thing that we must dispel is this: the city maintains no list of property owners or tenants. The only list that we maintain is a list of community associations. The only list that we have shared with appellants is a list of community associations. That is the only list that's maintained by the city. SDAT would be the repository of all tax information for all residents and all owners, property owners in the state of Maryland. you could just take judicial notice of the fact that every single piece of land in Maryland is owned and all pieces of land are recorded and maintained in records form are maintained in the SDAT database, but the city does not maintain a list. The city shared no list. The city has no burden to share a list, and the city is not at fault for any of the actions taken by any party in this appeal. The city's interest in this is that this requirement for notice is a constitutional requirement. And but for everyone being properly noticed, there are residents and citizens and tenants and property owners in the city of Annapolis who did not receive proper notice that this hearing is continuing or this hearing is even taking place. And they can walk into the circuit court regardless of the decision that the board makes. And the circuit court would find that there was error because constitutional notice requirements were not met. So the city's perspective is but for proper notice to all persons required by the city code, that we cannot move forward because then it becomes a nullity. And any one of those owners walks in and says, we did not get proper notice, it invalidates our process here today. So that is the specific reason the city joins the applicant's motion. And we note that there's a concession of at least 7 people that have received notice. Again, we want to reemphasize that there's no city list, so the city bears no responsibility to help or provide anyone with any information beyond our community associations list. And one person not receiving notice is a problem. Multiple, several, 7 or more people receiving notice is a huge issue. And the city is very concerned that the burden that the applicants bear in this situation is the same burden that the appellants bear when it comes to notice in different formats. So if the applicant is being held to a standard, it's somewhat unfair that the appellants not be held to the same standard. And with that, the city will rest.
Ms. Halleck, can you tell us about the list you relied on and from whom you got it, under what circumstances?
I have inherited this case from someone else, and I do say that this was the list that was maintained and provided for the prior appeal, and that was provided by the applicant. And that was and this was the list that was submitted by Mr. Rogers in the prior appeal, and there was no objection. So it is that we relied on. I want to also note something further. There is no way, if you're Mr. Braithwaite and Mr. Hyatt are requiring absolutely strict compliance with the notice requirement. But even using if I look up online, the ownership of a property on SDAT, which I'm familiar with that, those are often outdated and they're not accurate either. If someone, that's initially who owns the property, but those addresses are frequently outdated and also inaccurate. There is never an ability. 7 out of 700 is what we've got here. 700 notices and a handful didn't. There is never going to be perfect compliance. And I think that the board, in order to require that during COVID and knock on doors, there's just no way to make it perfect. So what is acceptable and what isn't? Even if I looked these up, it doesn't mean that it's absolutely accurate. So my point here is that this isn't just an attempt to, on a procedural way, to dismiss this appeal, which is a substantive appeal. And then the other factor here is that this is a new statute. This isn't like I keep making the mistakes and blaming it on others. I have made every effort to comply with this using the assistance of the city. And it was never clear, and I would renew that. It's not clear to me that the grandfathering clause excuses the need to notify tenants in this property. I mean,
Okay.
the board hasn't ruled on that. So given that, those are the issues we've already had. But given all of those issues that I've presented, for Mr. Hyatt to keep saying you made the mistake, you made it, and you blame it on someone else. I have worked diligently with the city to provide notice in good faith. If there's instructions on how to do it, or if I research the code and I try and do it, and me as a resident, I've never done this work before. I'm a family law attorney. And if it's not made available to the common citizens of Annapolis, then the application, nobody could ever appeal. Nobody could proceed. I have worked hours and hours on trying to comply with this strictly. And what Mr. Hyatt is trying to do in effect is to dismiss this appeal based on an absolute inability for me. I could never get all of these. I could never get 100% compliance. And so that's what's in the code. It says reasonably, if I can reasonably determine, and that's what your order says, that I could reasonably determine. Now, Mr. Hyatt said, go knock on doors. Well, I did.
Okay.
I researched the
Your-
shopping
your-
center.
Your point is well taken. We get it. We get it.
Mr. Chairman, may I say one thing?
Yep, go ahead.
And follow up. Perfection is not required. It's a snapshot in time. The notices have to go out to the property owners within 200 feet. That's been in the law for a long time. That's never changed. And so 15 days before, you check the SDAT website, and maybe there's transactions in process, and that's where there's no perfection. But on that date, you can comply. In this particular case, there's an old list of property owners within 200 feet. I suspect that list may have gone back to the original time 3 years ago when this application started and it was relied upon. That's a shortcut. That's a risk that somebody took and made a mistake.
So let me ask you, if you rely on the SDAT list and it's in error, is notice defective?
I don't know the answer to that. I would think it is not. If that's the best available opportunity you have to get property owners, a list of property owners within 200 feet, and you do it, and that's on a date 15 days prior to the hearing, and you use that list to send the notice out, I think you've done all you can do. But that's not what was done here. Absolutely
All
was
right.
not done here.
We're Mr. Braithwaite.
In this discussion we're having about the accuracy of the list, I'm able to look at Mr. Hyatt's exhibits and see dates of transaction for property, March 11, 2020. So this is as with respect to a property owned at 824 Chesapeake Ave in Annapolis, Maryland. We have a transaction date of March 11th of 2020. On a property from the SDAT related to a property at 919 Bay Ridge Avenue. We have a transaction date where the property switched hands of May 19th, 2020. As to 921 Bay Ridge Avenue, that also switched hands on May 19th, 2020. We have another sale of a property at 1018 Bay Ridge Avenue on June 1 of 2020. That tells me that the SDAT list is a very reliable place, because if it is telling you up to 2 months ago when property is transacted, property switched ownership, what it gives you a reasonable basis from which someone could see your attempts at compliance. Because what you're able to say is, on this day, 2 weeks ago, I downloaded the database, so I looked at the addresses, and from the addresses, I have these, and this is the most recent information. And what it is, it's not about perfection, but it's about showing that you have a methodology that's calculated to give notice to the widest variety of people possible. And you took all reasonable efforts to have the most up-to-date information. And so again, I don't want this to be, this is not a personal attack on Ms. Heidi Halleck. This is about constitutional compliance and compliance with the city code. So I don't want any statements from the city to be interpreted as saying anything more than Ms. Halleck is upstanding attorney of over 20 years in practice, and she's great at what she does. What we're talking about is whether the city code was complied with. And that's all my focus is as an assistant city attorney.
Yeah, we understand it. Let me see if any of the board members have questions. Christian?
I'm gonna just take a step back as a non-attorney on the board and ask the question that with 10 years not serving on the board. And I served twice as chairman. When we asked the question at the appropriate point of any application hearing, was proper notice provided for? Was it posted correctly and distribution to all appropriately done? And we rely on testimony and evidence at that moment to make a judgment call on the board that it was either done or was not done. We do not seek out evidence to the contrary, but if we're, as we're sitting here as a body and we have somebody at any one of those previous hundreds of hearings that we sat on stepped forward and said, I live here on the map and I've been waiting for notice. It would be a little funny because they were clearly there, so somebody got notice. But if we had evidence, if somebody came forward with evidence that a group of people did not receive notice, if there was evidence entered that compliance was not reached, we would be compelled to consider it. I don't know if that's what we're saying is here today. I hear a lot of speculation about 7 or 14 people. Is somebody submitting evidence that somebody else did not receive notice? Are we just saying, what do we say? What are we hearing? That's what I'm asking.
I think Mr. Hyatt and Mr. Braithwaite have told us that they know, and Ms. Halleck agrees, that certain people who should have gotten notice didn't. I don't think anyone has said that any of those people have come forward and said, I wanted notice and I didn't get it.
In response to that, there are two matters too. There's substitute notice. There's notification in the newspaper and there's publication on the property.
Yeah.
So that's designed as a fail-safe for if you don't get it, that there's also secondary notice. So maybe not primary, but that's the whole concept of publication in the paper, because if you don't get it, you're presumed to be notified by publication in the paper and posting on the property.
All right. Any other questions from the board? Michael?
Mr. Chairman, thank you. I guess how would you interpret reasonable notice, Mr. Hyatt and Mr. Braithwaite? What is reasonable? That the methodology has to be a methodology that you and you alone would propose, or that there's a good faith effort to comply with the requirements? And Mr. Braithwaite, the second question, you say in your motion, in agreement with the appellant, that were we to go forward, with the saying if this notice is satisfactory, that it would negate any action we take after this? If you could clarify that, I'd appreciate it.
You want me to answer first?
Yeah, one of you about the methodology, but the second one is yours.
The term reasonable is not used in the city code. Under 21-10-020, it states that you shall provide notice in a certain way. You shall, in all three ways. One, written notice mailed, one by publication in the newspaper, and another sign has to be posted. You shall do those three things, not a reasonable attempt to do those three things. You have to do them.
Okay, I'll grant you that. Now, but as I recall, unless my hearing's going bad, you also said it doesn't require perfection.
Right, and for example, I don't know how you can possibly identify tenants within 200 feet. You can't. You don't know if somebody has a basement apartment or a room they're renting. So what we've done to accommodate that is notice has been sent to every single property within 200 feet addressed to occupant. I think that's all you can do, unless you know that there are certain tenants. Like, you know, in the Eastport Shopping Center, there's storefront tenants. You can tell who the tenants are. So that you do the best you can under those circumstances for the notice to tenants. With respect to the notice to the property owners, as we just discussed, the best methodology is to go to the State Department of Assessments and Taxation website, and you can obtain on any given date the property owners within 200 feet. I think that's all you can do. And if there's something in transit or in the middle of a transfer and hasn't quite made it to the SDAT site, I don't think you can be penalized. But here we had SDAT changes prior to the list that the appellants relied upon going back a couple of years. They didn't look at the SDAT site.
The last question, Mr. Hyatt, if you would allow me. So if the shoe were on the other foot and this requirement in this instance was, and it often is, required the applicant to comply with this part of the code, and you were found to be 7 notifications short, would you be arguing against the dismissal?
Of course. If I was on one side, I would be arguing, and if that's what you're asking me, I've participated on both sides of the fence, but you can't go forward with deficient notice. And this is the third, at least, time that the appellants have failed to comply. That's the problem I have here. You give them a little leniency, okay, but how many times do you do that? And there's no repercussions if you fail to comply. Just kick it down the road while the applicant just sits there and bleeds money. It's not right.
Thank you.
All
Mr.
right,
Braithwaite,
you done, Michael?
Yeah, no, I had asked Mr. Braithwaite the
Yeah.
second question, as part of his
Okay.
motion.
So from my research, notice is a constitutional prerequisite to be able to hold someone accountable, right? It is notice and opportunity to be heard. And so without that notice and opportunity to be heard, the government can't take certain actions against you because you weren't apprised that something was going to be happening. Now, if we told you we were going to do something, we told you when it was going to occur, and if you had any objections to show up, you're then able to show up and voice your opinion about how you feel about whatever the topic is. Absent that notice, if we take action against you, it's unfair for the government to do that because the person didn't know the government was going to act and the person wasn't on notice. So this is actually something that's fundamental to the Constitution, that actions that proceed without notice are invalid. If the proper notice is not given, none of the actions that are taken after the improper notice can have legal effect, and that's for a very good reason.
Okay, thank you, Mr. Braithwaite. Michael, do you have anything else?
Yes, Mr. Chairman, thank you. I'm all set.
Anyone else, any other board members? Yes, Andrew.
So my question is about best methodology. We keep talking about best methodology. There's nothing in the code that describes what the best methodology is for providing the 3 forms of notice, correct? I mean, obviously posting the property, that's pretty self-evident, and notice in the newspaper, that's pretty self-evident. But when it comes to notifying the actual property owners, it's up to the board to determine whether the best methodology was put forward in complying with notice to the individual property owners. Do I have that correct? And Mr. Hyatt's saying best methodology, and the city saying best methodology is SDAT. Correct? Is that where we're at? I just want to make sure that's
Mr. Braithwaite's shaking his head negatively.
correct. So someone help me with that.
So the city doesn't have an opinion on best methodology. I would say the person that's most well-versed in notification requirements in the city of Annapolis is Mr. Hyatt.
Okay, so fine. I won't include the city on that, but then I'll direct my question directly to Mr. Hyatt. Then when we're talking best methodology, it's your opinion that best methodology, and I'm not taking agreement or disagreement with it, but you're suggesting SDAT is best methodology because it's most up to date, and it's up to the board to determine whether best methodology was actually implemented here. Is that fair?
I think it is the best methodology, but I think the board now knows that there was not notice properly given. So I don't know that you have to evaluate methodology as much as you have to evaluate was notice given or not. It's up to the appellant to have given the notice and to comply with the code. It's the appellant's burden. And it just so happens that I've been doing it for so many years, we discovered that SDAT is the way to go. There's really no other way to ascertain property owners within 200 feet unless you go to SDAT.
In response, there is a tax, the other methodology is the tax code, the tax listing on the tax map for the city. And rather than, if you understand, if there's 700 people on the list and you have to go to SDAT, that takes about 10 minutes, 15 minutes, depending, could be faster for each one of those. And that is outrageously time consuming. The other way to methodology would be to just look at what the tax map 52D, for example, grid 20, parcel 538. That's how this list has been put together. And I really stress this issue that that's at the absolute notice, and that notices are to be reasonably sent. There's but the secondary, that whether reasonable notice is sent to a person is also, there's alternative notice through the newspaper. So if a person
You're repeating
comes to
yourself.
if a person comes, and I'm just tying the two together, if a person comes to the city, Mr. Braithwaite's point here, and comes to before the city and said, how can you act because I wasn't notified? The simple legal response that he's aware of is, yes, you received substitute notice. It was posted on the, if you're a tenant within 500 feet or 200 feet, it was posted for your benefit. And secondly, if it's published in the newspaper. So that is the legal notice, and it is legal notice.
We understand.
Code says.
All right. Andrew, anything else?
No, thank you.
And thank you, Nadine. All right. I'm not going to dismiss the case for failure of notice. I think the notice requirement is intended to make sure that there's a reasonable effort made to get everyone with an interest in this notice so that they can protect their interests. I don't think it was intended to be an obstacle to citizens exercising their right to challenge decisions by the city. I would have, until a few days ago, said that, and I still believe that Ms. Halleck has made a diligent and good faith and reasonable effort to get the job done. She didn't have the benefit of the insights Mr. Hyatt has after 30 years or whatever it is practicing in this area, so she didn't go to SDAT. But Mr. Hyatt and Mr. Braithwaite raised an issue that they have to raise and that the board can't ignore. And that's people who were intended to get notice under the statute didn't get it. And we know that they didn't get it. We know who they are. And there's a remedy for that. And so we will see that they get proper notice. So what we're going to require is that Ms. Halleck, you'll let the parties know, the people that, based on your careful review of Mr. Hyatt's list, the people that you think deserve notice, invite Mr. Halleck or Mr. Hyatt and Mr. Braithwaite to let you know if they can think of any others and make sure they get notice. For reasons we'll come to in a minute, this case is going to have to be continued. We're not going to get to it tonight, so there will be time to do that. And Watergate got completely covered. You covered all the people on the city's list of associations. You used a list that had been used earlier in essentially the same case, and there had been no objection to it. So that's the basis for my conclusion that you acted diligently and in good faith. So the next issue is the standard of review in this case. And I'm delighted, much to my surprise, that you all seem to agree that we're bound to operate under the new ordinance 3419 and that the standard review is on the record. Am I mistaken in that anyway, Mr. Hyatt or Mr. Braithwaite or Ms. Halleck?
I don't think we can avoid it. I think it's applicable. I think Mr. Braithwaite's response indicated that as well.
Yeah,
And I do want to apologize to the board. Under my caption, my first sentence was from our stipulation. And so it didn't properly note that the position advanced in the city's response today was solely that of the cities and not of any other party.
Okay, so I agree, we need to operate under the new standard. And I think that means that we're going to need to revisit a number of things before we go into the hearing on the merits. So those changes also necessitate a continuance. And we'll come back to what the schedule will be in a few minutes.
Before we move on, I'm taking a note here. Am I to, in conclusion of that issue, I am to provide notice, notice of that hearing that we've had, that we've sent an updated notice to those persons on the list that Mr. Hyatt has noted there are additional changes, because he went through that carefully, and I want to make sure, I don't want to do this again, do everything that I think I'm supposed to do right, and then not have done it right. So I really need clarity.
Make the list of the people that you think need notice, send it to Mr. Hyatt, Mr. Braithwaite, say, tell us who else should be on here. That's
Mr. Chairman, I don't think I should have to review her list.
all right. All right, do your best then without the benefit of Mr. Hyatt's wisdom. No, Mr. Rogers, I'm sorry, we're not going to hear from you on this. Are you clear on that, Ms. Halleck?
Like mud, but I'm going to do my best.
Well, no one here is in a position to tell you who you have to give it to.
I
As I
understand
said, I thought you were in good faith before, but now we know there are some people who haven't gotten notice. You need do your best again, diligently and in good faith, to try to get notice to those people that you know haven't got it.
Okay.
Doesn't seem that hard to me. I mean, it may be hard physically and time consuming to do it, but the concept is not hard. Okay, so moving over to the review on the record standard, there are a number of things we have to do. I think, Ms. Halleck, first of all, you're going to need to restate your notice of appeal. In terms of the standard of review articulated in the new ordinance, the various types of error that you can appeal from as laid out in that ordinance. Any trouble understanding that?
Part of it is due to my understanding of what the new statute requires. I note that there were a bunch of amendments. I can't tell from the website, because at the city website, it doesn't.
The amendment gives you the language that I'm referring to. It says you can appeal from a decision of the board on these grounds, and it lists them. That's it.
She's offline.
Yeah.
She dropped off.
I still wasn't able to figure that out.
Heidi, are you back with us?
Yeah, are you there?
You're,
Can you hear me?
I can hear you. Your pictures, your video is freezing now and then, but I can hear you. Now I
Can you
don't.
hear me?
I heard
Am I
that.
back on?
I can hear you
How
now.
about this?
Yep, good.
Testing.
Okay.
So I didn't have an updated, accurate summary. I mean, I don't know what is in the ordinance that was fully passed, but I,
Just go to the council's website and go
And I-
to 419, and the last item in the list of things you can open is the amendments. And that contains the operative language on what's our grounds for appeal.
what was amended and what wasn't? You can't, it doesn't show. What was approved and what wasn't?
The
There were-
amendments
Chairman,
are
Mr.
approved.
Chairman, I don't think this is right. I mean, you know,
We're all
I
six,
should be giving her advice.
there were all 6 approved. I have no idea.
Well, you're a lawyer, you'll figure it out.
Exactly.
But I think if you put the amendments together with the original, you'll see what it is. Ross will certainly know what it is. All right, so we'll have a restated notice of appeal. And then the city, so appeal is on the record. That in most cases means we don't have any witnesses. We don't have any exhibits. It means that you make an argument based on what's in the record. So we'll come back to the witnesses in a minute. I will give the city time, adequate time, we'll come back to what the time is, to take a look at what the city designated as the record and decide whether you want to do a redesignation, whether you want to add anything to the record. And the reason I say that is because going back to the general principle of review on the record, that's what it is. If there's anything that you relied on in reaching this decision and you need it to support that decision, it needs to be designated in the record. So take another look and do that. And that may require the parties then to rethink the subject of witnesses and exhibits. And when you do that, let me tell you what my thinking is on that. There are very limited exceptions to restricting the review to the record certified up by the agency. One that I think may probably apply to this case is the appellants are going to be challenging the adequacy of the city's decision. Challenges might, for example, include that the information the city relied on wasn't reliable, that the city, under any best practice standard, should have relied on some other information that they didn't rely on. Those are the kinds of things that are arguably subject to the general rule that we won't have witnesses or exhibits. So, consistent with the general rule, I will ask each of the parties to let the board know, in light of this discussion, what witnesses or exhibits they think they need to offer, why, and how that's consistent with the exception to the general rule that I've described. All right, questions about that?
I'd like to jump in here.
Just tell us what's your question.
The difficulty here is appellants were not a party to this is a different matter, and I don't think the city intended that no witnesses were to be called. First of all, there were no changes to, although there's a change here, just the procedure that says on the record or de novo. They struck the procedure part, but there were no other changes to the code in different sections that are provided for the city, for the Board of Appeals, that evidence and witnesses, that evidence can be provided by the parties in section 2110.040. None of the changes were made there to say that the parties can present relevant testimony and evidence accepted by all interested parties. So I believe that the city, and I'm not going to talk about what a council member assumed or did not assume in submitting this, but I believe the understanding can be inferred from the code that testimony and exhibits are to be continued to be allowed under the board's procedures. Secondly, not being a party to this case the underlying matter. The city and the applicant convened and reached an agreement as to the mitigation plan. And appellants were not a party to any of that. So appellants and there is no record of what was negotiated or what wasn't negotiated or what was presented to the city or what wasn't. There is no record of what was considered. And if there needs to be a determination that the city, the planning officer, there was an abuse of discretion, how can I prove that? How can appellants prove that there was information not considered or that there was abuse of discretion if there's no record of what went on, what was considered, and how that was done? I know this is novel because this is a same thing with the notice provision. These things are new. But I believe that in order for anybody to make a decision, whether the chief police chief, or anybody, any of the department heads did not have proper information or did not consider the proper information, and it's an abuse of discretion, I think the board needs to hear from those parties to be able to make that determination.
The 3419 clearly says the appellant says on the record and the appellant bears the burden of proof. You need to prove that their process was defective in one of the ways identified in 3419.
Yes.
That's what it says.
Yeah, and in order to do that, to show that it was defective or that there was discretion or abuse of discretion or an improper decision at law, you need to hear, and they need to present testimony as to what was considered, what was done.
Well, if their record isn't adequate to support what they did, you win. So they've got to put it out there. Mr.
Fair
Braithwaite.
enough. I'll agree.
So the city, this from the city attorney's office, we see this as no different than any other certiorari appeal where the writing of the city must be sufficient to withstand the scrutiny of the Board of Appeals, and in conjunction with the argument that the appellant is going to bring to the table to show exactly why our writing does not stand up to the standards set by the code. So that we expect nothing else than a comparison of what the city code compels, what our actions were, and to the extent appellants perceive a gap, and that gap can be described as an abuse of discretion or clear error or lacking substantial support or lacking substantial evidence, then I think that that's the way everything proceeds. So lawyers deal with this all the time, dealing with a record and with appealing a written order. And we have a written order, and therefore the order speaks for itself. And we will labor to make sure we have all of the considerations in the work file, I'll say, kind of like an appraiser having a work file. We make sure that we get the work file together, but ultimately the product is Dr. Nash's redetermination and mitigation plan. And those are the written records which must withstand scrutiny.
Yeah, if you just put up the decision, I predict you're not going to do very well. You've got to show the substantial record that supports what you've done. And I'm sure you'll try to do that. And I think you also agreed that you're going to provide Ms. Halleck with the documents she was looking for. Is that right?
From speaking with Dr. Nash today, we expect E-Track to be up shortly, whether that's tomorrow. What was earlier an estimate. So to the extent E-Track it is up and running before the end of the week, or we could get into E-Track on the back end and provide the documents. Either way, we're willing to work to provide the documents requested.
Go ahead.
I want to address this issue and say my concern on this. Number one, as I said before, the appellants were not a party to the underlying case. And although Mr. Braithwaite says there's an order and therefore there's a record, well, there isn't a record. There's no trial transcript. There's no record. And this makes sense for what we're doing for purposes of the board to make a decision, but there would be no record for the circuit court to be able to review what happened with the city. And let me use just a simple example here. Let's say that I'm arguing as part of my case is that Director Nash failed to apply the standards suggested in the ITE curbs and other standards and recommendations that would reasonably be used by a urban planner. And I want to say in it, and the board, I can argue that to the board, but there's going to be an objection that's outside of the record, that material is not part of the record. And in the Court of Appeals, if I want to make that argument, it's not part of the record. What
That's where I'm suggesting that the exception may apply. And you're always able to make an offer of proof for the record to show the Court of Appeals what we excluded if we exclude something. And
Mr. Chairman.
Yeah.
May I be heard?
Yes, of course.
Let's not forget what this case is all about. If you recall, in your decision in March, you vacated the decision of the Department of Planning and Zoning in issuing the APF certification for 5 criteria, and you remanded it back to the planning director to consult with the other department heads, and you were very specific in your opinion about what was supposed to have been done. I think that the city, and I think even the appellants agree, that this case is all about whether the Department of Planning and Zoning through Dr. Nash and the other departments followed your directives. You gave specific instructions what to do: create new standards, explain why you came up with this and why you did that. And if they did that, then we should be able to have an affirmation of the APF certification. We're not starting all over. I mean, that's the record. Did we comply? Did the city comply? Not we. It's not the applicant. It's whether the city complied for the most part.
Well, we'll have to think about that a little bit. Certainly, we're not getting into any of the other 4 facilities. We're limited to 5. Before the standard change to review on the record, I would have agreed with you without blinking. But the new standard that we agree we're all bound by articulates a particular standard having to do with arbitrary, capricious, and substantial evidence in the record and that sort of thing. And I'm not sure that's any different from complying with the order, but that's the question.
You know, I think I said in one of the, many responses here that whether you call it de novo or on the record, I don't think makes a lot of difference in this particular case, because the city was acting on a remand. That's what happened here. I don't think there's much.
I guess I would remind everyone that probably the biggest difference in one of the biggest differences going from one standard to the other is the availability of deference to the decisions of the agency. So I think you all need to keep that in mind as we move forward. All right, a specific witness question that came up was the availability of Ross Arnett. If any witnesses are permitted, and if Ross is one of them that somebody wants up there, I'm not going to say that you can't call him because Joel says you can't call him. Joel and the witness are going to have to work that out, and Mr. Arnett will decide whether he wants to show up or not. I'll just leave it at that. And clearly, I think the appellants have argued again that the city really isn't a party. We've rejected that argument previously. We reject it again. The city is a party. The city's always a party to appeals. It's their order you're trying to appeal. There were a public testimony. You know, conventional practice tells you that on an appeal on the record, you wouldn't have any public testimony either. But in this case, my inclination is that there will be no live public testimony. And if members of the public believe they have something to say that fits in to the exception that I've mentioned to the general rule of no witnesses, will certainly accept it. It'll be marked, it'll become part of the record, and the board will take it for what it's worth. The hearing order will stick with the city, the appellants, and then the applicants. So that, E-Track-It. There was a public comment.
Wait, I'm sorry, did you say it's city applicant and appellants, right?
I said city appellants and applicants.
Okay.
I don't.
That's different, isn't it?
I don't think it disadvantages you. I think it's consistent with what was in the 3419.
Yeah, but I think that got amended out.
Well, maybe it did. And if it did, unless there's some other ordinance that controls this, I like it. The city puts it up there. The appellants have the burden of proof. They get to tell us what's wrong, and you can tell us why they're wrong about what's wrong. E-Track-It. We had a public comment that somebody was quite put out that they couldn't have access. Sally not here anymore? All right, Joel, you'll make sure.
Yes, her internet
Sally's calling you.
timed out, so I think she's trying to get back in, and this is her now.
All right.
Sally, you there?
I'm here.
Okay, good. I wanted to make sure Sally hears this. So we had a comment, as you know, Sally, that a member of the public was put out that they couldn't get access to what they wanted on E-Track-It in this case. I'm sympathetic to that. It's tough for the public to get information about what's going on, and that's a good system and it ought to be working. And so as we work out what the actual hearing schedule is, I think we will assume that E-Track-It will be working well before whatever that hearing date is.
I heard otherwise.
Okay,
I've heard otherwise.
what's that?
I've heard that the E-Track-It has been down for 2 months.
It's going to be up again. Sally said that.
But I get it. It's not
It
going to
hasn't
be.
been down for 2 months, but
I don't care how long it's been down. It's going to be up.
I don't know when it will be back up. They told me tomorrow, but my IT manager called me today, so I'm worried that and I didn't get a chance to talk to him, so I'm worried that's bad news, but
Well,
hopefully it will be soon.
Let me say this, if there's not a way to get public information to the people who want it in time for the hearing, we're going to delay the hearing so they have time to get it.
I could always make a web page for the project.
That'll be fine.
How would anybody know to go to the webpage rather than
You
E-Track-It?
put a notice up on the E-Track-It site.
Right.
But you can't because it's down.
Smart people will figure out a way to do that. They don't need lawyers to do that, Heidi. Julian, somebody's going to figure it out.
This has hampered my ability to prepare for this case, and that's what I put in my motion.
We're going to fix it.
So my question is, in designation of the record, are you getting to that, or are we done?
The city is going to redesignate the record. Once the city's done that, you're going to redesignate whatever evidence you think you need to offer that's not in the record.
All right, I'm going to just ask a couple of questions in that. A, the record would be on E-Track-It, so I might not know because
No, they're going to file a record that will be available outside of E-Tracket.
So here's my question. And I, in my motion, is the prior hearing, can that be amended? The testimony and evidence, now Mr. Hyatt has transcribed and submitted the transcription to the court, to the board. So all of that hearing has been transcribed. Can we have that as part of the record so that in the event this goes to the Court of Appeals, that we would know based on all the testimonies there and it's available?
No,
I'd like to amend and include on the record, because this is really a further hearing and a further appeal, and that record has been established.
no,
And-
not. You can make an offer of proof. You're always welcome to do that. But this appeal is to the most recent certificate.
This is a new case. The prior case was not appealed, and that's it. Over.
I'm going to say this is going to make it, and I think the city council is going to have to deal with this. But I understand how you're applying it in this case because the board's had a lot of testimony and evidence. But in going forward, you've just made, the decisions you've just made now will make it impossible for any resident to set aside a decision that was made behind closed doors by the city and in concert with the applicants. And how are we to know? There's no record of it. How do we know? There isn't. And that's, for example,
That's the way administrative orders are
That's-
appealed all the time.
that's not how the county does it. The
If
county
they-
allows witnesses.
If they misinterpreted the law, you don't need evidence to show that. If they didn't get enough facts, you can point, they're not in the record. They should have had these facts in the record. If they had facts in the record that they shouldn't have relied on, you can point to that. That's the way it's done.
For example, if they failed to inspect the outflow pipe, I'm not going to know if they did it or not, and you're not going to know if they went down and they took pictures of it or they didn't take pictures of it, and they're required, and there's all this damage to the pipe. Just use an example. There's all this damage to the pipe, but yet at the end of the day, they say, we're just not going to do that, although the standards require that they do it, and it would be they failed to act, or that in the traffic study, we couldn't tell if they inspected for 3 days or 1 day, or they're in compliance. There's a lot of evidence that that applicants will never be able to bring to the board that we brought to the board so the board can consider it, and you cross-examine and you heard from everybody, and that's why you're comfortable making this decision.
They're going to have a traffic study. You can point out whatever you think is wrong with that study. It'll say how many days they were here and there. And if it doesn't, that's the basis for you to argue that it's not an adequate traffic study.
Well, how about my example with the outflow pipe? How do we know that? How do we know that they didn't consider it and took a picture of it? Except that we brought in this case, we brought the engineer, Mr. Rogers had pictures of the outflow pipe that show that it's damaged, cracked, and in poor condition. And that the inspector and the city inspector said, oh, that the 24-inch pipe goes into a 28-inch pipe, for example, and that's going to cost money to fix, and that's an issue here. But how would we have known that? And I'm just using one of many.
If they think that's important, it'll be in their record. If they don't think it's important, it won't. And you have the point that they didn't consider it.
Mr. Chairman, you want to direct Ms. Halleck to section 22.28 about how mitigation works? I mean, I don't think the appellants need to be coached.
Yeah. Okay. So here's what I'm going to suggest. I think you all need to think about what time you need. And I think when we have that discussion, we need to have our indispensable scheduler, Jackie, available to us. So, and for notice reasons, in order to keep this simpler, we will continue the hearing until October 21st. On October 21st, it will essentially be a status call where we'll see where we are and we'll set the date for the later hearing.
I do have one more question, always.
Go ahead.
Mr. Braithwaite has, for example, prepared his testimony for his witnesses and put it on the record. Is that something that would be considered on the record? Is that something that I would put on, or testimony and evidence? I would, in designating the record, if he's self-servingly he's provided and submitted to me and the board testimony that he expected his witnesses to testify to and wants to put it on the record, and then he wants to refer to that. And is that appropriate? And is that something, if he's putting on, I've just asked that it be struck. If he's putting on testimony and we don't allow witnesses.
Well, there's nothing in the record yet. I don't think he hasn't designated that as part of the record on appeal. He has to decide what's in the record on appeal. That's a very important call for him. I mean, that's the make or break set of decisions in the case for the city, as far as I can see. If it's a complicated case, as we know from the last round, and if the city, when they come back and tell us what they think they want to do, if they think it's sufficiently complicated that they want to offer one or more witnesses to explain what they've done, I'd be inclined to let them do that, but of course they'd be subject to your cross-examination.
And then similarly, if you're going to say he's allowed, are the appellants allowed? And if we just explain.
If you meet that exception that I've described more than once. So anything else we need to deal with?
And one more time, if Mr. Braithwaite designates the record, then I have the opportunity, the appellants have the opportunity to also designate further sections.
That
would be in accordance with the appeal, with an appeal.
I would recommend that if he wants that kind of testimony, he make it live, subject to cross-examination, because I think if he's going to put that in, fairness really requires you to have a chance to cross-examine. So I would frown on offering their sort of declarations unless there's some compelling reason why they can't be there. And then we might have to think of something else, like produce an alternate witness for cross-examination.
If the city may be heard briefly.
Of course.
We know that that additional testimony was only prepared out of abundance of caution to allow the prior proceedings to proceed in a orderly fashion, such that everyone could be apprised of what the testimony was going to be and prepare the cases for that testimony. So
believe me, I appreciate that very much. I appreciate the efforts of all counsel to try to make this complicated case move along as efficiently as possible.
So Mr. Braithwaite, are you saying that you're going to designate that, or you're just going to wait and see, and then we're going to deal with it on the 21st?
Don't pressure him. He's got time to decide. They're going to designate the record. We'll see what's in the record. When do you think you can do that, Mr. Braithwaite?
So I think I actually probably will need like 2 weeks. I think by the 21st, I should be able to identify all the parts to the record. One of the things that's novel in this appeal, it's the first time that we are applying an on the record standard. And Absolutely. As you said, the designated record is the make it or break it part for the city. What the city wants to be able to demonstrate to the board is that we took the remand seriously and we followed the city code to what we hope to be a degree that satisfies the Board of Appeals. So with that in mind, we will go back through the record to make sure that we not only have supports for our decisions, but you could see the rational basis for all assumptions, all facts, all law, and you could, and you and the city and the residents can see that we acted appropriately in this manner. And that's what the city hopes to accomplish with the record that we put forth before you.
That would be great. That would be great. So if it's possible to get that to Ms. Halleck a day before the 21st, so she can have some reaction to it when we talk about schedule, that would be great.
I'm going to renew this. Let's assume for a minute he designates only a few things that only help his case and doesn't include comments from citizens or other things, other matters that he may deem extraneous or that don't help his case, because that's important for the city. Let's say he doesn't put any of those in there. In the appeals court, first the plaintiff, the appellant, designates the transcript, portions of the transcript or the record. And if the portions that are not included, the other party has the opportunity to add
That's
on.
a different context. That's not an administrative appeal. That's an appeal of a trial court decision.
What if he
Mr.
picks and-
Braithwaite is admitted to practice here. He bears all the responsibility and obligation to this board that you do and you bear to a court. When he certifies the record, he or whoever certifies it is certifying, subject to penalties of perjury, that is everything the director relied on in making the decision. And unless there's evidence to suggest someone's in bad faith, we're going to take it as that. And we've never had anyone in bad faith before this board in my 8 years. And Christian's 10 years, I think.
Started when I was 13.
Okay, anything else?
May I get a clarification?
Yes, sir.
You talked about the exception.
Yep.
Would you mind explaining that, just so we're all clear?
I'm not clear.
Okay. This is different from even an appeal of an administrative agency's regulation, for example, where it's a much more transparent process. So in applying the usual rule of witnesses only, we need to keep that in mind. Of no witnesses, the usual rule of no witnesses, we need to keep that in mind. And we also keep in mind that the ordinance we're working under is one that gives citizens the right to challenge determinations by a government agency. So with those things in mind, and I think there's some inference, Ms. Halleck suggests, from the changes that refer to the order of, unless it was amended out as Mr. Hyde suggests, the order of presentation, that there would be some testimony. So in my mind, the testimony is limited to what the appellants need to make the case that the record relied on by the agency is unreliable. Unreliable either because it did not include things it should have included, or it included things that it shouldn't have included because they're not relevant or not reliable.
So the exception is witnesses.
The exception is witnesses.
Yeah, the rule is, it's on the record, no witnesses, but for certain circumstances, there may be a need for witnesses, what you're saying.
Yes.
Okay.
Yes, Mr. Braithwaite.
If I may be heard, on the question of the order presentation, you said city appellants and applicant. We noted that there was a 2.5-hour imposition limit imposed. Do you propose that the time be evenly split such that The essence is, city, you have 30 minutes, prove your case.
We'll,
And I get it.
we'll revisit that on the 21st.
Good enough, thank you.
We'll see what people think they need to do and we'll make a decision on that then. I'm impressed that you all are trying to move this along efficiently, and I don't want to cut anybody off who's got information that's consistent with what we're trying to do, to be fair here.
I want to address one more issue.
One more.
If the board may not be willing to address it, but Mr. Braithwaite, as a fellow counsel, has advised me that I am not to contact the Alderman Ross Arnett, because that he represents him, and therefore I cannot contact, likewise, I'm sure, with any other alderman to discuss any of the matters that the city may or may or not have done. As my
I don't know. I don't know, take it up with
That's not, yeah.
legal ethics people. I'm not going to rule on that. I did say that if he's a proper witness, I'm happy to hear his testimony if he chooses to disregard Mr. Braithwaite's advice. You've got to decide whether you violate an ethical rule if you contact Mr. Arnett in violation of Mr. Braithwaite's direction. That's your problem, not mine.
the rule, the way he's applied this, it's really sort of intimidation here in the, and I want to say, he represents everybody in the city, all the way down to the.
That's the argument to make in your case if there's an ethical problem. It's not an argument to make to us. And I know Mr. Braithwaite's intimidating. He intimidates me too, but he doesn't intend to. Anything else?
We can address additional things on the 21st. Thank you.
Good.
Can I ask a question? Are you trying to close?
Yeah, but go ahead.
Were there any exhibits for this meeting? I'm sorry.
There were no exhibits for this meeting.
Other than the 2 public testimony that we were going to put in the record? Or
Right,
are we putting
right.
those-
That's it.
Okay, so we're going to make those T, we're going to make those T instead of P.
Yeah, whatever you want.
Okay, thank you.
And just for future reference, Tammy,
Mhm.
any public testimony that comes in, you can mark it and make it part of the record.
Okay,
Everyone on the board's going to look at it. I'm not going to rule on whether they should look at it or not. And they'll give it whatever consideration they think it deserves.
then another question would be if they go to audio where the public testimony is going to be allowed to be made right in the meeting, we will no longer make that as an exhibit. We will allow that just to be public testimony. Correct?
We're not going to have any of that.
Okay, we may, I was probably under the impression that that might happen, but if it's not,
Not so far. The only public testimony we're going to have is written.
okay, sounds good, thanks.
The exception, I guess, could be Ross Arnett if he testifies.
Okay. Thank you.
We'd extend him that courtesy if we have to.
If I could be heard briefly, I would say that there's a difference between a person serving as a witness and a person providing public testimony.
Yeah.
My instructions were limited to appearance as a witness in the matter. They were not limited to public testimony. In the prior hearing, one of our Alderman Gay, participated, but he was not subject to direct and cross-examination by any party. And if any resident of the city of Annapolis has a right to provide public testimony, then every resident of the city of Annapolis has a right to provide public testimony. But a witness, I do believe, would require other qualifications and competencies that the law requires of all witnesses. So that is what I would say in reserve on the matter of who can testify and what can they say.
Yeah, you're correct. We typically don't swear alderpersons when they give us a statement. And that's what I was anticipating would be the nature of Alderman Arnett's testimony were he to give it. But if appellants want to try another approach, we'll deal with it when they tell us. All right, I'm looking for a motion to adjourn.
Then look no further. Motion to adjourn.
Second.
I heard a second. All in favor?
Aye.
Aye.
All right. Thank you all for your patience and your wisdom. Talk to you on the 21st.